I'd like to call us all to order, if I might. I'd like to welcome you all here to the John Marshall Harlan Class of 1920 Lecture in Constitutional Adjudication. I'm Kim Shepley. I'm the director of a new program called the Program in Normative Thinking, Program in Law and Normative Thinking, which is based over at the Center for Human Values. And I'm delighted that SPIA and also the Brazil Lab are bringing today to you a very exciting program. The Harlan Lecture is one of the biggest events on our calendar each year because we have the opportunity to invite distinguished jurists to the Princeton campus. And today we're very fortunate to have with us President Luís Roberto Barroso of the Supreme Federal Court of Brazil. Now, before I introduce President Barroso, I want to make two other brief introductions. One is that you should meet John Marshall Harlan, Class of 1920, after whom the lecture is named. Now, anyone who works on the U.S. Supreme Court will know him as the second Justice Harlan who served on the Supreme Court of the United States. He was on the court from 1955 to 1971. While he was at Princeton, he was the editor of the Daily Princetonian and the president of his class. On the court, he was often considered to be the intellectual leader of the conservative wing of his day. So he's a frequent dissenter from Warren Court decisions. He often defended federalism against the centralization of power, and he never accepted the idea that the 14th Amendment incorporated all of the Bill of Rights. But he was nonetheless a strong defender of many individual rights and a justice who was intensely respected even by those who did not share his views. So in honoring the second Justice Harlan with this lecture, Princeton calls attention not only to this particular justice, but also to the fact that even though we don't have a law school, we have had, as far as I can tell now, 10 Princeton alums who have served as justices on the U.S. Supreme Court. And so this is a tradition that we're proud to carry on, and we like to internationalize it a bit by inviting distinguished judges from other jurisdictions. So first introduction is to the person after whom the lecture is named. The second introduction is to the Federal Supreme Court of Brazil. Since the new constitution in Brazil went into effect in 1988, the Supreme Federal Court has been, as it puts on its own website, the guardian of that constitution. That is a big job. This is a court that decides 100,000 cases a year. There are 11 judges appointed by the president with approval of the Senate. You might recognize where that idea came from. And since 2002, it has had its own television channel, broadcasting not only when it makes decisions, but it also broadcasts its deliberations. I think it's the only court in the world to do that. The Brazilian Supreme Federal Tribunal has also been one of the lead creators of something that's now called in our academic literature Global South constitutionalism, with expansive social rights, indigenous rights, environmental rights, anti-discrimination law, LGBTIQ plus law, and much more. But this court also plays a political role. A subset of the judges are judges of the Supreme Electoral Court, and they have original jurisdiction over trials of political leaders. So the Brazilian Supreme Court is now one of the most influential courts in the world, and it has far eclipsed the U.S. Supreme Court in its defense of democracy and human rights. Now, for those of you on the left of the political spectrum, this is the court you would rather have. For those on the right of the U.S. political spectrum, the Federal Supreme Court of Brazil provides Exhibit A for why U.S. judges should not be inspired by their foreign counterparts, okay? And so now let me introduce to you our distinguished guest of the day, President Barroso. He was appointed to the Supreme Federal Tribunal in Brazil in 2013. As I mentioned, the court, actually a subset of the judges of that court, sit as the electoral court during election season. And in the very contentious 2022 election, he was president of that court and had to hold the line on many challenges that were made by the then incumbent president to the electoral system of Brazil. He's since now become the president of the Supreme Federal Court, and as in that role, he also becomes president of the National Council of the Judiciary, which is the body that actually supervises the entire judiciary in Brazil. And in that role, he has been remarkable about promoting Afro-Brazilians, women, indigenous people, and others who have not been so represented in the Brazilian judiciary into positions of leadership. I'm proud to say he holds an LLM from Yale Law School, so he's very gifted in US constitutional law. His SJD, his PhD, was from Rio de Janeiro University. He's written more than a dozen books on Brazilian constitutional law and comparative constitutional law, many articles published all over the world, including quite a few in English. Since 2018, he's been a senior fellow at the Harvard Kennedy School, and he's also been a regular member now for many years of the Yale Law School Global Constitutionalism Seminar. And in his role as justice and now president of the court, he's been one of the strongest defenders of the rule of law and constitutionalism and democracy in Brazil and elsewhere. And so appropriately enough, the topic for his lecture today is democracy, populism, and institutional resistance, the Supreme Court in the game of power. And so I welcome our Harlan Lecturer for the year, the Honorable President Luís Roberto Barroso of the Supreme Federal Court of Brazil.
Thank you. Good afternoon. It's a great pleasure. It's an honor for me to be here and to share with you all some thoughts and some ideas on this subject: democracy, populism, and institutional resistance, Supreme Courts in the game of power. I would like to thank the organizers of this event, and very particularly my good friend and great scholar, Kim Chappell, who has been so kind during my stay here. I have divided this presentation in three basic parts. The first one is revisiting the basic concepts, which are democracy, populism, and the role of Supreme Courts. Second part is what's happening in the world. And the third part is democratic resistance, failures, and successes. So I will begin our conversation by briefly revisiting the basic concepts that I think are relevant to understand and to navigate our subject. Starting with democracy. Constitutional democracy was the winning ideology of the 21st century, having prevailed over all the alternatives that appeared: communism, fascism, Nazism, military dictatorships, and religious fundamentalisms. Constitutional democracy is a concept that contains two sides of the same coin. On one side, we are talking about popular sovereignty, free and fair elections, and rule of the majority. And on the other side, we are talking about limited power, rule of the law, and respect for fundamental rights. Most constitutional democracies around the world have in their institutional arrangement a Supreme Court or a constitutional court that has as one of its roles, I would say, to arbitrate the tensions that sometimes occur between the two sides of the coin, between the will of the majority on one side and the rule of law and the protection of fundamental rights of all on the other side. One other comment I want to add about constitutional democracy is that nowadays democracies are built on votes, rights, and reasons. And this means that democracies are not limited to the electoral process, but democracy requires respect for everyone's rights and an ongoing public debate that legitimizes political decisions. So this is our basic idea of democracy with the values we need to protect. The second concept I want to go through for a couple minutes is authoritarian populism. The world is witnessing a authoritarian populist wave that is often anti-institutional, anti-pluralist, and a wave that poses serious risks for democracies. In most cases, populism bears the mark of personalistic and charismatic leaders that manipulate fears, needs, and desires of the population, often promising simple and mistaken solutions for complex problems. Populism can be left-wing. It's warm in here. I think I can remove this. Populism can be left-wing or wing these days. Right-wing populism has posed more dangers to democracy. And the hallmark of right-wing populism is the division of society into us, the pure, decent, conservative people, and them, the cosmopolitan, corrupt liberal elites. There are several causes for this phenomenon of authoritarian populism and this sort of division of society. I am going to address it a little later in our conversation. The extremist and authoritarian populism throughout the world, it usually uses the same strategies. Direct communication with their supporters, usually using social media. Second, bypassing or co-opting intermediary institutions that make the interface between the people and the government, intermediate institutions like the press, like the legislature, like civil society organizations. And the third strategy is usually to attack Supreme Courts that have as a role to limit the power of populist leaders. And quite often, authoritarian populism deploys also as one of its strategies the use of disinformation, misinformation, hate speech, and conspiracy theories. So this is a brief note on populism. And the third concept I would like to address here before moving on is of Supreme Courts and the role that they play. Most democracies, almost every democracy in the world, reserve part of the power for public agents, public officers that are not elected. And that is the judiciary. So the judiciary is not supposed to represent the will of the majority, but to interpret the Constitution and the legislation. At the top of the judicial system in many countries, in the US, in Canada, in the UK, in Brazil, you have a Supreme Court. In Europe, they usually have constitutional courts that has a slightly different format, but whose role, just like Supreme Courts, is to interpret the Constitution. Supreme Courts, or constitutional courts, have three main missions, I would say. The first one is to ensure the rule of the majority. The winner has the right to exercise power, and consequently, courts must defer to political decisions made by the elected branches of government, except when they go against the Constitution. The second mission of a Supreme Court is to preserve democracy, preserve the rules of democracy, preventing majorities from abusing the power by changing the rules of the game on their own benefit. And thirdly, the role of courts, of Supreme Courts, is to protect the fundamental rights of everyone, including the rights of majorities. It's not necessary to stress here that there is usually some sort of tension between authoritarian populist leaders and governments and Supreme Courts, because the role of Supreme Courts is to interpret the Constitution. And a Constitution exists to limit the power of the majorities. And populist leaders usually overvalue the power of majorities. So the natural tension exists between the branch of government that has the mission of limiting power of the majority and whoever exercises this majoritarian power. So these are the basics I would like to share before moving on. We spoke a little bit about democracy and what it means, a little bit about populism, and about the role of Supreme Courts. So I now move on to our second chapter, what's happening in the world. I'll be talking about what's happening in the world, not what's happening in America. Although constitutional democracy was, as I said, the winning ideology of the 21st century, something seems to have gone wrong with democratic constitutionalism in different parts of the world. In a scenario that has been referred to as democratic recession, democratic backsliding, abusive constitutionalism, competitive authoritarianism, illiberal democracy, or autocratic legalism, among other derogatory terms. And these expressions have been used to identify political processes that have occurred in countries like Hungary, Poland, Turkey, Russia, the Philippines, Venezuela, Nicaragua, to name just a few. In all these cases, as has been pointed out by Levitsky and Ziblatt, the erosion of democracy does not come from a coup d'etat led by a general and his or her subordinates, but by leaders, presidents, and prime ministers that are elected by popular vote, but after taking office, with small changes and small moves that are not a problem in themselves, but altogether help this process of eroding democracy. And even consolidated democracies have suffered with this sort of populism and especially extremism, as we're going to see later on. So I talk now a little bit about some of the causes of the advance of authoritarian populism throughout the world. And the causes are diverse, but one thing that we should have in mind is that many of them are linked to the dysfunctions of democracy itself. The promises now delivered of prosperity and equal opportunity for all. The democracy should be, as we all know, a collective project of self-government. And whoever feels excluded from this project, of course, is not committed to it. So one thing that I think Democrats should bear in mind is that authoritarian populism flows quite often through the shortcuts of democracy. That being said, I think there are three major categories of causes for the rise of authoritarian populism from where I see it from the global south, but trying to understand what's going on throughout the world. So I identify political causes, social and economic causes, and cultural identity causes that I want to briefly mention. The political causes include the deficit of representativeness in electoral systems. Whoever travels the world will notice that no one is satisfied with his or her electoral system. Wherever you go, people don't feel they have voice or that they are well represented. Second, the second political cause, I would say, the negative perception of politics, the belief that politics revolves around the interests of politicians and not the interests of society. And third, the appropriation of the state by extractive elites. I employ the expression extractive elites in the sense suggested by Darren Acemoglu and James Robinson in their acclaimed book, Why Nations Fail, meaning elites that place the state and the institutions at the service of their own interests when they are not outright involved in pure and simple corruption. So all these three political causes that I just mentioned, deficit in political representation, negative perception of politics, and extractive elites dominating the states, all this leads to an erosion of trust in institutions. Secondly, there are what I call social and economic causes that include a persistent poverty within countries and among countries in a very unfair international order. Secondly, the relative increase of inequality within countries and among countries. And thirdly, social stagnation and difficulty in upward mobility in many societies around the world. So globalization and the knowledge economy have negatively impacted various segments of society. And the rise of artificial intelligence heightened these risks. So the world is going through major social and economic changes that impact the way people perceive democracy and politics. And the third and last cause is cultural identity causes. Identity politics, the way I see it, enabled progress in the rights of women, Afro-descendants, gays, people with disabilities, and indigenous communities throughout the world, and that has diminished the power of traditional hegemonic elites. That's one first reason. The second is the emergence of stark divisions in societies, such as between urban and rural populations, religious and non-religious individuals, and globalists and nationalists. Whoever looks at society in any country or in many countries will clearly perceive this cleavage, this division between people that have a totally different perception of life, different views of what the role of the country and society should be. And the third cultural cause, I would say, is the search for scapegoats for problems like crime, unemployment, and cultural transformation. These scapegoats can include immigrants, liberal, gays, Afro-descendants, Jews, you pick it. That's one characteristic of authoritarian populism. You need an enemy. And you can change enemy, but you always have someone to blame for the things you think are going wrong. So and concluding this topic in cultural and identity causes, I think Democrats have not yet, at least not successfully, I would say, they have not convinced some social groups that recognizing the rights of women, gays, Afro-descendants, people with disabilities, and Native communities, these are not progressive causes. The dignity and equality of all people are the causes of humanity. So that's a perception we need to overcome to make sure we don't have a retrocess in these advancements that were very important. I now want to address the clash that often occurs between authoritarian populism and Supreme Courts. As I said before, court acts as a barrier against the abuse of power by the majorities. And populist governments are often hostile to constitutional values as they defend the unlimited power of political majorities, attack checks and balances mechanisms, despise minorities, and even subordinate fundamental rights to the will of the majority. In classical constitutional theory, a fundamental right is typically a right that cannot depend on the will of the majority. The populist strategy is to claim that courts represent elites with interests opposed to the majority. So unsurprisingly, as I said before, you always find some sort of tension between populist governments and Supreme Courts. As a consequence, populist leaders usually try to capture the Supreme Courts or the constitutional courts, attacking them verbally and also through some concrete actions replicated around the world. First one, packing the courts with submissive judges, forcing the opening of vacancy with changes in retirement rules or an increase in the number of seats at the court. This has been a playbook in different parts of the world. Second, suppressing powers of the court, approving constitutional amendments and legislation that remove jurisdictional powers from the courts or hinder their performance. And third, threat of impeachment of Supreme Court justices, as we have seen in countries like Venezuela and even Brazil. So anti-democratic leaders usually use one of these strategies to capture the courts and to put the judiciary at the service of legitimizing authoritarian practices by the regime. So I now, still within this chapter, move on to some very important consequences of authoritarian populism in the world today. The first consequence that we can see in different parts is the loss of civility. It's part of the playbook of the authoritarian populism to morally disqualify whoever opposes it. That's the first, I would say, consequence. Most popular authoritarian populists, they are very aggressive in their discourses against whoever is opposed to their ideology. The second important consequence that we see today is a global articulation of extremism, usually far-right extremism, that captures the conservative camp in many parts of the world. Democracy has room for liberal, for conservatives, for progressive. Alternation in power is a blessing. The problem is not with being liberal or being conservative. The problem is with being extremist, because extremism means intolerance, means not accepting that the other can be different than me. And that's the major problem with extremism. And what we see throughout the world is that the conservative camp in many countries has been captured by this extremist view. A third consequence that we see in many countries of the world in what regards to authoritarian populism is political manipulation of people religiosity. In many parts of the world, authoritarian populism captures religious leaders to advance its purposes. And the rhetoric includes claims such as, my opponent does not defend Christian values or the family, or they are agents of the evil. And an intriguing phenomenon here, it's the combination between an ultra-liberal economic view, liberal in the European sense, being pro-business, and radically against government regulation. So this intriguing combination between an ultra-liberal economic view on one side and an ultra-conservative stance on social issues, opposing women's rights, LGBTQI rights, and affirmative actions. That is something that is a pattern that you see. People that are vigorously pro-business, they, in order to fit in their camp, they also have to be very, very conservative in what regards customs. Fourth, the loss of the importance of truth with the use of social media to spread disinformation, hate speech, and conspiracy theories. So this use of character assassination as a political strategy and lying as a political strategy, as if it were an ethical, acceptable behavior, has generalized in many parts of the world. And this is something we need to fight to make lying wrong again. And fifth, disregard for knowledge institutions. It's also a common trait among populism around the world. This anti-intellectual stand against professors, against intellectuals, more generally, this disdain is evident in attacks on the press, universities, think tanks, and intellectuals in general. So these are some consequences that I think we can extract from the observation of authoritarian populism around the world as common traits that unify them. And then we come to the third and last part of our conversation, which is democratic resistance and failures and successes, meaning in what cases courts were able to stop the advance of authoritarian populism and the cases in which courts were not capable of doing that. Unfortunately, this second category is more often than the first one. So I start with some cases. The first one, and more paradigmatic, is what happened in Hungary, and Professor Kin-Chapelle is probably the main scholar that has analyzed what went on in Hungary, a country where after the fall of the Soviet Union, the constitutional court relished in power and prestige at a first moment, but then after the Fidesz party came to power in 2010, this situation progressively deteriorated with attacks on the court and then the capture of the court with the traditional playbook. Increase in the number of judges. He reduced the retirement age to open new vacancies, changed the criteria of appointing judges to make political influence more important, removed powers of judicial review, especially regarding constitutional amendments, and in 1213, the government had already obtained full control of the court and other institutions such as the parliament, the universities, and the press. Another dramatic case in Latin America was the case of Venezuela. Hugo Chavez took office in 1999, and in the same year he had a new constitution approved, and he remained in power with successive re-elections until 2013. In 2002, he suffered an attempted coup d'etat. He was back to power in 2 days, and when the Supreme Court did not convict the officers that were involved in the coup, he retaliated the court, increasing the number of judges and facilitating the removal of judges through impeachment. And after that, the Supreme Court in Venezuela became a co-participant in the exercise of authoritarian power in Venezuela, ratifying many absurdities that were committed. And finally, the most probably dramatic case was the case of Russia. What happened in Russia was exemplary. In 1989, after the fall of the Berlin Wall, the Constitutional Court rose as an important actor in the democratic transition in Russia. In 1993, however, the court clashed with Boris Yeltsin over decrees suspending parliament on the understanding that the president had exceeded his power. What happened next? Yeltsin then called a popular referendum and won support to dissolve the parliament and the court. By the end of 1993, Russia had a new constitution, but no longer a constitutional court. When the court was reinstated in 1995, it had a much smaller role and was already submissive to Vladimir Putin. So these stories, these cases in which the courts clashed with authoritarian populism and were defeated are recurrent throughout the world. It also happened in Turkey, Nicaragua, in Ecuador, and Peru, and Bolivia, just to mention a few countries in Latin America. There are three success stories. The first one is maybe pre this authoritarian populism wave, and it occurred in Colombia. A very important decision in 2010. What happened in Colombia was the president then, in his first term, had a constitutional amendment allowing him to run for a second term. And the court validated this second amendment. And during his second term, he approved a new constitutional amendment allowing him to run for a third term. And then the Constitutional Court decided that a third term was changing the original constitution and was unacceptable. The rationale underpinning this decision is that in Latin America, a third term successive is the path to dictatorship. So in a very bold decision, the Constitutional Court decided he couldn't run for the third time, and the decision prevailed. I would say also here in the United States, in the previous elections, there were many challenges to the victory of President Biden, judicial challenges. 3 cases reached the Supreme Court. The judiciary here in this country, in none of these cases, accepted to void elections in any of the states. making the electoral results prevail. This is also deemed to be a success story. And the third and last one I want to mention occurred recently in Poland. In Poland is a rare case, I would say, that managed to overcome authoritarian populism. In the 2023 election, the Law and Order Party was defeated. The Law and Order Party had done to Poland constitutional court pretty much the same things that Orban had done in Hungary. Anticipated the retirement of judges, limited their jurisdiction, required a supermajority for the invalidation of laws, gave the executive the power to publish or not the decisions of the court, and refused to call to office 5 judges that had been appointed by the parliament. As I said, in 2023, the Law and Order Party was defeated, but as Kim Chappell showed in a recent article published in the New York Times, rebuilding institutions and overcoming the traumas is not easy, especially because the Constitutional Court itself that had been captured hinders the process of changing and going back to democracy. And finally, another success story, I think I'd say, is the case of Brazil. And this is the final note I want to make. In 2016, in Brazil, after 14 years in power, the Workers' Party left office following the controversial impeachment of President Dilma Rousseff. And in 2018, a new president was elected, presenting himself as an outsider, despite having served multiple terms in the National Congress. Here, and now I'm going to just describe facts. I'm not issuing any opinion here. But according to many observers, a series of events revealed the democratic risks the country began to face, including, and here are the dangers that most pundits point out in the political process that occurred in Brazil in the past years. First, politicization of the armed forces, with the appointment of active duty military personnel to government positions and thousands of retired military personnel to a wide variety of public offices. So politicization of armed forces in Latin America is one of the most dangerous problems for democracy. Second, in the past government, there was a repeated glorification of the military dictatorship. There were direct attacks on the Supreme Court and personal insults directed to the justices. Direct attacks on the press and personal insults to our journalists. Attempt to discredit the electoral system. And this is a point I want to make, especially for people who are not familiar with Brazil. Brazil had a tradition of electoral fraud since the beginning of the Republic. At a certain point in 1996, we created an electronic voting system. So we got rid of paper ballot, and the election is totally controlled by an electronic voting system. The electronic voting system is based on, of course, a software that has its source code open to all political parties, to the federal police, to the Attorney General, and to academic institutions to verify its integrity. After it's verified, the program, the software is sealed, and then it is inserted in ballots that never go online. It's impossible to hack the system because the program, the software is inserted in the ballots with pen drives. And it won't run if it's frauded by any way. So since 1996, there has been no case of fraud in the electoral process in Brazil. And the attempt that was made in the past government to go back to paper ballot was, as I felt it, a major risk to the integrity of the entire process. And today we know that we're dealing with people that were capable of invading the three headquarters of government, the Supreme Court, Congress, and the presidential palace. So just imagine what could happen with paper ballot being counted manually in the voting stations where they thought they would lose. So one of the main battles that was fought to preserve Brazilian democracy was avoiding the return to paper ballot. This might not make too much sense in this country if electoral fraud was not a problem. But in Brazil, it has always been a problem. We overcame the problem, and there was an attempt to go back to the problematic system. Going on with the threats that we faced, there was the refusal to concede victory to the winning candidate. Then there were support for people that were camping before the barracks, the military barracks, after the election, claiming for a coup d'etat, for not respecting the result of the elections. Stunning as it may sound, thousands of supporters of the former president asking to the military takeover in a military coup, avoiding the president to be inaugurated. We're not talking about dozens or hundreds. We're many thousands of people. And they were tolerated by claiming for a coup d'etat. Coup d'etat. This is such a fortunate country. There isn't even a word in English for coup d'etat. And in January 8th, 2023, right after Lula's inauguration, there was the invasion of the headquarters of the three branches of government. And according to the press and to the investigations that are going on, there was a major articulation for a coup d'etat led by, apparently, high personalities of the previous government. This is still being investigated. I don't have any opinion on this matter. So, just to be clear, I am describing facts. I'm not issuing any opinion. That's all documented, historically documented. So, the role that the Supreme Court played in this environment is our final chapter here. The Supreme Court played a major role in Brazil during the past government. First, in dealing with the pandemic, there was a major denial of the severity of the pandemic. So the Supreme Court played a major role assuring the states and the municipalities the power to act against the pandemic. There was an executive order by the federal government saying that only the federal government could do anything, and we struck down this executive order. The court ordered a vaccination plan and made vaccination mandatory, and validated state and local laws that prohibited religious gathering during the pandemic. The court also rendered important decisions in environmental issues, decisions for the protection of the indigenous communities. We launched criminal investigations against far-right groups that were claiming for a coup d'etat. We criminally convicted one member of Congress that was summoning people to invade the courts and remove the justices by force. And we are processing in criminal judgments the people that were caught during the invasion of the three buildings that were headquarters of government. And there is this ongoing investigation on the attempted coup. For people that are not totally familiar with the Brazilian system, the Supreme Court in Brazil plays a role that is, to a certain extent, different from the role played by Supreme Courts in most part of the world, Supreme Court or constitutional courts. First, because Brazil has a very comprehensive constitution. The Brazilian constitution, as any constitution in the world, democratic world, it addresses the separation of power, it has a Bill of Rights, and it organizes the state. Brazil is a federal state. So the Brazilian constitution does this. But the Brazilian constitution also addresses the social security system, the tax system, the public healthcare system, the educational system, the protection of indigenous communities, the protection of the environment, the role of the government in economy. It deals with the media. It deals with the protection of the elderly, the family, the youth. The Brazilian Constitution deals with a great array of matters that in most countries of the world are left to politics. So in Brazil, different than other countries, the border, the frontier between law and politics is less clear than other countries. So the Brazilian Constitution has a long provision dealing with protection of the environment. In other countries in the world, if someone files a lawsuit claiming measures against climate change, probably the judge will say, this is the wrong door, this is a political matter. But in Brazil, the Constitution describes the actions that the government must take to protect the Amazon, to protect the Pantanal. And so if you are not doing what the Constitution says, you're violating it. And that's the role of the Supreme Court, say you are violating the Constitution. So we have many decisions regarding environmental protection. Just to give you a flavor that in Brazil, due to this institutional arrangement, the Supreme Court plays a distinct role as compared to other courts in the world. And besides that, here in the United States, to reach the Supreme Court, there is what's called the case or controversy requirement. You need a case, and you only get to the Supreme Court through an appeal after going the trial level, the appellate level, and then you reach the Supreme Court if writ of certiorari is granted. In Brazil, we do have this system, but we also have the possibility of the filing of direct actions before the Supreme Court, challenging a statute on its face, or challenging the lack or deficiency of a public policy that was provided for in the Constitution. So the possibility of accessing directly to the Supreme Court and the many private and public actors that can file these actions make the Supreme Court a final arbitrator of just about anything of modest importance in Brazil, be it economic, social, political, or ethical. So it's an institutional arrangement that makes the access to the court easy, and a constitution that deals with many matters that in other countries are political. So the Brazilian Supreme Court decides the most divisive issues of the Brazilian life, from demarcation of indigenous lands and research with embryonic stem cells to the import of tires. I made a short list here. We have decided same-sex unions, gay rights, affirmative action for people of African descent, deforestation of the Amazon, abortion, drug policy, attacks on democracy, social media regulation, health measures during the pandemic, outsourcing labor relations and other labor issues, criminal judgments of politicians, religious classes in public schools, and many other issues. So the Brazilian Supreme Court decides the most divisive issues of the Brazilian society. And people that we please today, they are displeased tomorrow. So here, as anywhere else, the relevance of a court cannot be measured in surveys or in polls, because many times the correct decision is not popular. When the court, was a decision by myself, ordered this intrusion of an indigenous land, there were 1,000 indigenous and there were 5,000 invaders. And we ordered that the invaders be removed. But if people would have a survey in that region, we would lose 5-1. And of course, polls are not the proper way to measure the importance of court of justice. Of course, when a court becomes powerful, as the Brazilian Supreme Court has become, not for its own will, but because this is the institutional arrangement, you become a political target, because there is always dissatisfaction. If you decide in favor of indigenous communities against, let's say, the agribusiness, they will be displeased. And vice versa. If you decide in favor of taxpayers, the government will complain. If you decide in favor of the government, taxpayers will complain. So if you are a Supreme Court justice in Brazil, probably anywhere in the world, you better have a good psychoanalyst, because you will be always having a fair amount of rejection, because it's part of the job many times to displease. There are some reactions in Congress, and there are proposals of impeachment. There are proposals of changing and stripping the powers of the court. And this is part of the game of political debate. And we try to deal with this in a very mature way. So once again, thank you all for being here and for the attention. I prepared 3 conclusions. 3 conclusions. I even wrote them. First, courts alone are not capable of resisting authoritarian populism. The participation of civil society, the press, and at least part of the political class is essential. There's no superhero here. In Brazil, at the decisive moment, the armed forces did not embark on the authoritarian adventure either. So the institutional resistance in Brazil had the court playing a very important role, but the court alone would not have been able to do it. So I think was the democratic sentiment of society, including press, civil society, and as I said at the last minute, the armed forces did not accept the call for the coup. Second, democracy, this is very important what I'm going to say. Democracy is experiencing a moment of discredit in different parts of the world. It is necessary to make severe diagnosis to identify the reasons for this fact. Many people no longer identify with the values that have brought us here: substantive freedom, equality of opportunities, and dignity for all. And many others never, in fact, did benefit from these values. So we have a very critical view of the rise of authoritarian populism, and I think we should have, but we need some autocritic, because democracy has not been inclusive of all. And that's my final idea, my final takeaway here. The whole world will experience a time of darkness with more might and less rights, more arrogance and less justice. These will be times of resistance and effort to keep the lights on. History is not linear. It is made up of advances and setbacks. But our role as citizens, as workers, as civil servants, as intellectuals, is to push history in the right direction. And the right direction is that of good, justice, and inclusion for all people. That's probably the most important message. We Democrats, we need to be aware that people that are excluded can and are often captured by authoritarian adventures. So we need to make democracy a more fair political regime. Thank you very much for the attention. Thank you. Bon. Thank you.
I came up here because there are now time for questions, and there are at the bottom of each aisle microphones, actually. So if you want to ask a question, and we always like to try to get students to ask questions, but other people are also allowed to ask questions. So if you'd like to ask a question, if you could please come down, that would be great. And while we're waiting for some people to come to the microphones, I wonder if I can start by asking you a question, if you don't mind.
Sure.
And that is that one of the things for which your court is known are two actions that were sort of taken in defense of the preservation of democracy that got a lot of headlines here in the U.S. One was that after the election denialism that accompanied the last election, your court disqualified the prior president for running for 8 years. Our court had a similar case in which it declined to do that. So I think it would be interesting, for everyone to hear how your court did that. What was the law that you used to do that? And related to that, there was another case that got a lot of headlines here in the U.S., which is that you closed down X by Elon Musk until he agreed to comply with Brazilian law and came back. Okay, that was what all people knew here. What would be helpful, I think, for this audience to know is what was the law? You weren't just deciding policy questions, you were applying the law. And so how did you do those two things?
Okay. The first, the disqualification of the former president, it was actually done by the Superior Electoral Court. In Brazil, elections are run by the judiciary. So we have at the top of it the Superior Electoral Court, and in all states there is a state electoral court. And elections are run and overseen by the judiciary, not by politicians, but by judges. The Superior Electoral Court has 7 members. 3 of them are justices from the Supreme Court. So usually the electoral court, Superior Electoral Court, conveys the position of the Supreme Court because there are 3 justices there. In Brazil, the electoral legislation establishes that a politician can be stripped of his political rights, meaning the possibility of running for office, in case he has abused political power or has abused economic power. And what the electoral court decided was that before the elections and after the elections, the former president claimed that there was fraud. He summoned all the foreign ambassadors that were accredited in Brazil for a meeting and said he suspected that there was fraud, and in more than one circumstance he said he had evidence that there was fraud. So he was summoned by the electoral court to present the evidence, because if there was evidence, of course we would do something. There wasn't any evidence. So the court considered that the repeated campaign against the integrity of the elections, accusing of fraud without any evidence, and having said that had evidence, not having it, was abuse of political power. and for that reason, he was stripped of political rights. That's what we have done. And that was before the investigation for the attempted coup, which occurred afterwards. As for X, the question, although it was very politicized, it was much simpler than I think was in the press. Basically, X removed from Brazil all its employees. And the law is a digital platform to operate in Brazil needs to have a representative there to be summoned if there's anything wrong going on. So once X removed all representatives in Brazil, it was against the law, and its presence there was stayed until the employees went back, and X is now back. The main conflict is, as I said, there was this major confrontation with extremism in Brazil. And so a few decisions, very few decisions, for removal of content were ordered. One of them, which was the last one, the last drop, was a post that someone that lives in the US, running away from the Brazilian judicial system, was given the name of the police officer that was conducting the investigation against the former president, the name of the police officer, the name of his wife, the name of his daughters, and his address, and summoning people to come and hostilize them at their residence. So I think in any civilized nation of the world, that would not be considered free speech. That was an instigation to violence, and I think that was the proper decision. So the confrontation, when they say censorship, we are talking basically about crimes or near crime behaviors that would be very dangerous, or frontal attacks to the institutions. So, and the international coverage wasn't quite faithful to what was actually happening. That's why I accepted to talk to the New York Times, so that the world wouldn't think we were doing something authoritarian when we were fighting authoritarianism.
I think it's October 16th, 2024, New York Times interview. Yes, so we have a question. I think you're the, please introduce yourself.
Oh. Hello. First of all, thank you so much for coming to speak to us. I'm a junior here. My name's Lily. I'm in the history department and hope to go into law. You've addressed both kind of issues of the separation between politics and the judicial in various nation states, as well as kind of the emerging impact of social media on the erosion and or sometimes help of democracy and populist movements. In the US Supreme Court, they have very often shied away from the media. There's no cameras at all. Evidently, that's very different in Brazil. Can you speak a little bit to how you've seen the age of social media and the broadcasting of both hearings and discussions impact both the reaction to the court in Brazil and also the way in which the court has been able to either mitigate or, in some case, suffer abuse from populist leaders?
That's all right. What's your name, honey?
Lily.
Lily. So, as I said, having a very comprehensive constitution dealing with many issues makes the frontier between law and politics sometimes blurry or not so simple to establish. So, age of social media, and then the broadcasting of judgments in Brazil. What happened with the age of social media, with the internet, is the internet had a very positive consequence, I think, in life. It democratized access to information, access to knowledge, and access to the public space. And that was great. However, before the internet, in order to reach the public space, you needed to use the traditional media. We're talking about television, radio, and journals, press. So before the internet, for an opinion or any news reach the public space, you had some sort of editorial control according to journalistic ethics and journalistic technique. With the internet, with personal blogs and personal sites, anyone can reach the public space with no filter whatsoever. So the internet, at the same time that it democratized access to the public space, it also opened the avenues for disinformation, misinformation, character assassination, conspiracy theories, slanders. So we are living in a new world. So, Lily, every country is now trying to draw the proper line to protect freedom of expression, but also to avoid the world to fall in an abyss of incivilization, of hate speech. It's very difficult to draw this line. Europe has done it. In Brazil, there are bills in Congress being discussed. In this country, the Supreme Court kind of postponed this discussion to some moment in the future. But I'm sure that we won't escape having to regulate it in some way. The problem with the world is that with the polarization, even what's common sense have become controversial. So we all, no matter who is conservative or who is progressive, we all agree that child pornography should not be allowed. We all agree that terrorism should not be allowed. We all agree that you cannot sell, well, depends, in Brazil, you cannot sell weapons online. You cannot advertise human trafficking online. So there are basic things that should be prohibited because it's common sense. And in other countries, including this one, once you start having foreign interference, dramatic interference in politics, in elections, or incentivizing racial hatred, you're going to have to do something. So I'm pretty sure that regulation is inevitable, but it's not easy to draw the line. We must acknowledge that. As for the broadcasting of judgments, and just to be clear, as Kim said before, we don't broadcast the hearing only. We broadcast the actual deliberation process. We debate the cases. It's online because it's in YouTube and it's broadcast. There are downsides to that. First one, it's much easier to reach a consensus when you're in a closed room, first. Second, many times the opinions got a bit longer, and sometimes the opinion is addressed not to the peers, but to the public. It might happen. And third, very rarely, but when happens that we have a harsher debate, a harsher discussion, that's on the headlines, it's a reason for intrigue all over. So these are the downsides. What are the upsides, in my view? First, in South America and in Brazil, the social imagination is that behind any closed door, there is something sketchy, there's something wrong going on. So the image of 11 justices debating publicly and presenting their reasons for a decision, it's a good image for justice. So I said at the outset, democracy these days include votes, rights, and reasons. You need to justify what you're doing. That's the first reason. The second reason is there is kind of a didactic goal in the broadcast. people learn a bit about justice, and a lot of people watch it. I don't know, sometimes I feel they could get bored to death, but a lot of people watch it, the deliberation. And in the third place, the deliberation in Brazil, and this is a Portugal inheritance, is public. It's always been public. The sessions are public. The novelty is it being broadcast. So the session being public, and there's always journalists covering the court. If you don't broadcast, you are subject to the interpretation of the journalists that are there. And sometimes it might occur that the description of what happened is not very precise. And it happens sometimes. So the fact that I can show the video, now this is what I said, not what's written here, makes a difference. So there are downsides, there are upsides, but no matter if I like it or not, it's irreversible. Like the Brazilian society likes this transparency, and there's no way we can go back to non-public sessions. What do we suffer? You become a public figure. Here in the United States, if a Supreme Court justice is walking down the street, very few people will recognize him or her. In Brazil, this won't happen because we are all known, because we are on television, we are on the news, we decide the most divisive issues in the Brazilian society, and now everyone in Brazil has an opinion about anything that's being decided by the court. So we are public figures for good and for bad.
Next, you can introduce yourself, please.
Yes, hello, my name is Murilo. I'm from Brazil, but I'm a PhD student here in sociology. And I mean, I just want to preface that I really like your lecture, and I think the role of the Supreme Court in kind of advancing and defending social rights in Brazil is just unquestionable. But I had a question about a new model that has been used it's starting to be rolled out in Supreme Court decisions, which is the negotiation of conciliation. And I'm talking about the case of the marco temporal, which, just for the sake of the audience, is...
The case of what?
Marco temporal. Mm-hmm. Which is a legal thesis that was deemed constitutional by the court, that indigenous lands were only able to be recognized by the state as indigenous lands if indigenous groups were present in the land at the time the Constitution was proclaimed. And that was, as I said, deemed constitutional by the Supreme Court, but then Congress passed a law that enshrined that principle into law, like limiting claims of recognition of a lot of indigenous groups. And instead of ruling on the issue, the court decided to adopt a model of conciliation, where different parties, including parties that would have claims to those lands, parties of the agribusiness and indigenous groups, would negotiate and reach a consensus before the court to make a decision. And this process was questioned by one of the indigenous groups that was meant to defend their rights, as they claimed that the negotiations weren't being done in parity, and that the principle of negotiating social rights was in and of itself not acceptable to the group. So I wanted to ask you, thinking about the role of the Supreme Court and of the Constitution of having kind of those principles as a red line that can't be surpassed, how do we conciliate this counter-majoritarian role of the Constitution that you outlined with the principle of negotiating issues around a core constitutional issue that was deemed constitutional by the court? Thank you.
Okay. So, what's your name?
Murilo.
Murilo. So, let me briefly explain it to people that are not familiar with the case. The Brazilian Constitution has provisions protecting in traditional indigenous lands. So, traditional indigenous lands should be demarcated by the government to protect the indigenous cultures. Many areas have been, over 200 areas have been demarcated, and there are many claims for new demarcations. When the court decided the case, I wasn't at the court, some time ago, the court decided, or not decided, the court said in an obiter dictum that the indigenous communities could claim the demarcation of lands as long as they were occupying those lands in October 5th, 1988, the date of the promulgation of the Constitution. So there was an obiter dictum saying the indigenous communities can only claim demarcation of their lands if they were there when the Constitution was enacted. Obiter dictum. Years later, a case came to the court, and the court, I won't say properly it overruled, because an obiter dictum is not a holding, it's not an actual decision. But the court decided that no, that wasn't so. The indigenous communities could claim the demarcation of any land that they had been expelled and had conserved over the years a vindication for the land, trying to return to the land, even if they could not get it. And we said, trying to return to the land doesn't mean filing a lawsuit, because that's not according to their culture. But being around, going back, and trying to reoccupy it. So that's what the court decided. And then Congress passes a law saying indigenous lands can only be demarcated if the indigenous peoples were in the land when the Constitution was promulgated. So the statute said, the law that was approved said something different than what the court decided. The Constitution doesn't say anything about being there or not being there at the time the Constitution was promulgated. So there is a tension between what the court decided and what the legislature approved. There is a legal discussion here. If it's not in the Constitution, can the legislature decide differently than the court? First discussion. And second, should the court make its will prevail over the will of the legislature? These are two issues that could be discussed in this lawsuit. The rapporteur of the case, in Brazil, when a case reaches the court, it's randomly distributed to one of the justices. It's a bit different than the system here. The rapporteur, in this case, instead of ruling immediately, he said, let's see if we can find a middle ground between what the legislature decided and what the indigenous communities want. It's a very tough negotiation. If it doesn't go anywhere, the court is going to decide whether the statute is constitutional or not. But I think it was a wise decision to at least try to find common ground instead of investing in this tension with Congress. If it goes back for judgment, everyone is going to vote the way he or she thinks that's proper. But of course, if you can reach a consensus, it's much better. So this is what is at stake at the moment. They are trying to see if the positions can be reconciled, because otherwise, the court will have to decide either against Congress, either against the indigenous communities. If we can avoid that, it's better. If we can't avoid, we're going to decide. But I think it was worth the effort, and I think it was a wise decision. My position, because I have stated in my opinions clearly in favor of the indigenous communities, is clear and unquestionable. However, I still think that trying to find a compromise is an important try.
If we have time for maybe one more question, Marco, introduce yourself.
Thank you so much for the fantastic lecture. Really enjoyed it. My name is Marco. I'm a second-year student here at our School for Public International Affairs. And you talked about this playbook of the retirement age, a number of judges with constitutional courts in a comparative scenario. Recently, Germany became the first among the rare examples to be proactive about this democratic backsliding with
What?
Germany became proactive about democratic backsliding with the Federal Constitutional Court and the amendments to specify the age and the retirement and the different requirements for judges. So I was wondering, of course, this political will is not always present in every country, but what are other ways to be proactive rather than retroactive about democratic backsliding within the context of state capture and Supreme Courts?
Do you want me to say something about the German amendment?
I'm familiar
You
with
know
it.
better. Okay,
Yeah.
good.
What happened in Germany is, but I'll be happy to listen to you. And I always learn from, Kim and I, we became friends. We attend every year the Global Constitutionalism Seminar at Yale, and they invite Supreme Court justices from different countries and outstanding scholars from very few universities, and Kim is one of the stars of the event there, and I'm always happy to listen to her. I think what happened in Germany, to be true, I know what I read in the press. I didn't study for answering this question, but my impression is there is a risk in Germany that an extremist view might win elections. Extremism usually clash with courts. So before that happens, they kind of entrench it in the Constitution some basic rules to make it more difficult to change these rules in case a extremist government wins the elections. That's my impression from what I read. Do you agree with it?
Yeah,
Okay.
basically. It's just that in the German system, you need a two-thirds vote of the parliament to elect a constitutional judge. And the worry is that the AfD, this extremist party, might get a third or a third with its friends. And then they can block appointments to the Constitutional Court and close it by just attrition. So they changed the rules that if the parliament, the lower house, blocks these appointments, it'll go to the upper house for a vote, where it's very unlikely that the AfD can actually control the relevant majority. So they were trying to get out ahead of this and figure out a way to prevent not just if the AfD wins, but if it gets a blocking vote on constitutional judges. So it was just approved in December, so they're out ahead of their election. Yeah.
One more?
Oh, but what then the question actually I think was not about the German case, but about what do you do if you see extremism coming, how do you protect the institutions?
Oh.
That's a much harder question. The German
No.
one's easy.
Well, I think this is one observation. When you see it coming, before it arrives, there are measures you can take. And I think that's what, where's our... Yeah. So I think in Germany, they kind of foresaw the risks and they're trying to minimizing it. That's one thing. So when a authoritarian populism reaches power or is close to power, there are a few things a court can do. First thing is do nothing and say, that's not my job. And that usually ends up with an irrelevant court. Second possibility is a clash between the court and the populist government. You face it. And as I said before, in most cases, the court will lose, as happened in Hungary, Poland, Turkey, Russia. And the third possibility is the court being able to galvanize the resistance, bringing together civil society, at least part of the political class, civil society, knowledge institutions, and try to create like a moral blockage. I said a moral blockage because in Brazil, if, hopefully it didn't happen, and maybe the risk wasn't that big, but if the leader of the army the commander of the army, as the press says, I haven't seen the evidence, but the press says that in a meeting, the former president, mentioned the idea of a coup d'etat with the support of the commander of the naval forces. And then the commander of the army said, I'm not joining. I always wonder what would have happened if he had said, let's go for it. But of course, it's not just a one-man will. He represented, I think, the sentiment of the troops that he leads. So, although there was not great sympathy for the elected president, I think at the last moment, they were quite legalist in the army. But if he had accepted and there was a coup, courts don't have weapons and the purse. It's a famous quote from Federalist 78 by, if I'm not wrong, Alexander Hamilton. Could be James Madison, but I'm pretty sure it was Hamilton. He said, court is the least dangerous branch because we don't have the money and we don't have the weapons, the arms. So, to be totally sincere, there isn't much a court of justice can do against a coup, except for this moral resistance. But moral resistance can be more powerful than one thinks, but never alone. That's a fight you never win alone.
That actually is an optimistic note to end on. We've hit 6 o'clock. I know we have one more question. Maybe you can come up and ask him afterwards. But given that we promised you it would all end at 6, I think we need to call the proceeding to a close. And moral resistance is a good note to end on. So thank you so much for inspiring us all.
Thank you so much.